Welcome back. In this unit, we're going to discuss excuses, performance excuses. In this subunit, we're going to discuss the various excuses and how they're different from each other. All right, what are excuses? Well, excuses are essentially performance defenses, right? Once the parties have entered into a contract, something happens or there was some contingency that the parties didn't expect, and now one of the parties is saying, I should be relieved of my obligations under the contract. I should be excused from my performance. The four basic excuses are mutual mistake, impossibility, impracticability, and frustration of purpose. We'll also talk about a less common one, but still one that you need to know, unilateral mistake. The common themes in all of these excuses is that something beyond the control or the expectations of the parties caused performance of one of the parties to be either impossible or very costly. The other theme is, did the party claiming the excuse bear the risk of this event or this fact that the parties did not contemplate? As we go through it, the themes will be clearer and the issues that we're going to be discussing for each of these excuses will coagulate, hopefully. All right, so let's differentiate between the excuses. So once again, we said we have mutual mistake, impossibility, impracticability, and frustration of purpose. What is the excuse of mistake? Well, the excuse of mistake is where both parties assumed something when they entered into the contract, which later turns out not to be true. What is impossibility? Well, impossibility is slightly different in the sense that something happens after the parties entered into the contract, which makes performance by one of the parties impossible. So in impossibility, we're looking for a supervening event, something that happened after the parties entered into the contract. Mutual mistake, we're looking for an existing fact that the parties had an erroneous belief about when they entered into the contract. Impracticability is the progeny of impossibility. So something happens after the parties enter into the contract that makes performance of one of the parties not impossible, but impracticable, unreasonably expensive. So once again, the impracticability fact pattern is very similar to the impossibility fact pattern in that we have the parties entering into a contract and then something happens afterwards. Frustration of purpose, very closely related to impossibility and impracticability. We have the parties entering into a contract, then something happens afterwards. We have a subsequent event, or also called a supervening event, that causes the purpose of the contract for one of the parties to be frustrated. In other words, something happens and now I don't need this contract anymore. That is frustration of purpose. Let's look at a few fact patterns to help us learn to differentiate between the various different excuses. Remember, our excuses are mutual mistake, impossibility, impracticability, and frustration of purpose. So here's our first fact pattern. Bob promises to sell a famous painting to Mary for $200,000. After they enter into the contract, but before they consummate the transaction, before Bob delivers the painting to Mary, a fire hits the storage facility where Bob is storing the painting, and the painting is destroyed. So which excuse is implicated by this fact pattern? Well, first, we have a supervening event, something that happens after the parties entered into the contract. What is the supervening event here? A fire. All right, so what is the result of the supervening event? Well, the result is that Bob's performance is now impossible. The painting no longer exists. It's impossible for him to perform under the contract. It is impossible for him to deliver the painting to Mary. Does Bob have a good excuse for impossibility under this fact pattern? That we'll discuss later. But for now, let's just focus on differentiating, deciding which excuse is implicated by what fact pattern. And this fact pattern implicates the excuse of impossibility. All right, let's change the fact pattern a little bit. This time, Bob promises to sell a famous painting to Mary, just like in the last fact pattern. But after the parties consummated the transaction, they discover that the painting was a forgery. So it wasn't the famous painting at all. What excuse is implicated by this fact pattern? Well, you'll notice in this fact pattern, there is no supervening event. Nothing happens after the parties enter into the transaction. What happens is that they discover that what they believed at the time they entered into the contract is not true. They believed it was a famous painting, turns out to be a forgery. So because there was no supervening event and the parties had an erroneous belief when they entered into the contract, this is a case of mutual mistake. Will, in this case, Mary have a good excuse of mutual mistake in this fact pattern, which means that the court will undo the transaction and will make Bob give back her money, and Mary will give back the painting to Bob. Does she have a good excuse? Well, we'll talk about that a little bit later, but for now, let's understand that this type of fact pattern implicates the excuse for mutual mistake. All right, continuing on, same basic fact pattern. Bob promises to sell a famous painting to Mary for $200,000. Mary intends for this to be a gift for her significant other. Before the parties consummate the transaction, Mary's significant other passes away. So what excuse is implicated by this fact pattern? Well, number one, we have a supervening event. We have a supervening event, which is the passing away of Mary's loved one. Does this supervening event make Mary's performance impossible? No, it doesn't make it impossible, does it? She still can pay the money for the painting and take delivery of the painting. Does it make it impracticable? Well, remember, impracticable means it becomes very much more expensive, and it doesn't become any more expensive. Mary still pays the $200,000. So the excuse that's implicated by this fact pattern is frustration of purpose. The purpose for Mary entering into this contract no longer exists. Her loved one has passed away, and she no longer needs the painting for the gift. So her purpose of the contract has been frustrated. Does Mary have a good excuse? Will she be relieved of her performance under the doctrine of frustration of purpose? We'll talk about that in subsequent lessons. All right, in our final fact pattern, Mary owns a large wooded plot of land, and she hires Bob to clear a road through the land. And Bob charges her $20,000 for these services. When Bob has completed about 10% of the road, a large windstorm hits the area and knocks down a lot of trees, and these trees fall down in the path of the road that Bob is clearing through Mary's wooded land. The fallen trees cause Bob's cost to finish the road to increase significantly. So now the question is, what excuse will Bob claim? Right? Is it mutual mistake? Is it impossibility? Is it impracticability? Or is it frustration of purpose? All right, so we have a supervening event. So it's not mutual mistake. Remember, mutual mistake is when the parties have an erroneous belief when they enter into the contract. Here we do not have an erroneous belief about an existing fact. What we have is a supervening event, a subsequent event, which is the windstorm that knocks down the trees into the path of the road. Has Bob's performance become impossible? No, Bob's performance is not impossible. He could still clear those trees away. Has it become impracticable? Yes. His performance has become impracticable. At least that's his argument. It has become excessively more expensive, excessively more costly for him to perform under the contract. Will he have a successful excuse? Well, we'll talk about that in our subsequent lessons. So what are the challenges for you as a law student analyzing an excuse fact pattern? Well, you have two major challenges. Number one, recognize which excuse is implicated by the fact pattern. And that little exercise we just went through, looking at the 4 different fact patterns, that should help you decide which excuse is implicated by the fact pattern. The next task is even more challenging. One party is claiming the excuse and they want to be relieved of their obligations under the contract. Look at the fact pattern, look at the position of the parties, and do you think that the party that is claiming the excuse should bear the risk of, if it's mutual mistake, the mistaken belief, or if it's one of the other fact patterns that the party bears the risk of that supervening event or the consequences of that supervening event? This is a little bit more difficult, and our subsequent lessons will go through some examples, and hopefully after we go through those and after we meet in class and discuss them too, that you'll have a better idea of when a court will say, no, you will not be excused of your performance under this contract because you should bear the risk of either that erroneous belief or the consequences of the supervening event.